on our side, we really kind of did everything that we possibly could. And I know she was trying to do everything that she wanted to do on her end, but it wasn't meant to be on that. And so it ended up turning into a little bit of a disaster.
Jim, back by popular demand, we have you here to talk about more estate planning stuff.
Well, thank you. I said it feels great to be back in the saddle here.
No, it's great. You had 20, so far as of today, 20,000 people have watched your video, which is awesome.
Yeah. And thank you. And thank you to all your followers. That's absolutely amazing. So it's wonderful.
It's such a valuable service that you provide and the knowledge that you bring. So we want to go over a couple of things here because people don't want to make mistakes. And a lot of our viewers are very DIY, and a lot of our viewers want help with this. So if people are going through setting up a trust and everything accompanying it, what are the biggest mistakes that you have seen people make over your career, and how can we avoid those?
Absolutely. One of the biggest issues, and this may seem so funny when I say this, people signing and notarizing their trust. That honestly is one of the biggest mistakes. We spend all this time getting the plan in place and getting all the documents, bound and shipped to them. We have sign here sticky tabs everywhere. And a lot of times we get people that'll call us 6 months or a year later. They're like, "You're going to kill me. We didn't sign anything." And so then we end up having to go through and update all the dates and reprint and reship. And there's a little bit of a cost that goes associated with that. But sometimes that second time around, they go, "Okay, we're not going to do that again." But believe it or not, that's probably one of the biggest issues is people not signing their trust initially, which again, if you don't sign your trust, that's just a big stack of papers. It's an expensive stack of papers that you've got.
So take me through an estate planning horror story that you've experienced because they made a mistake.
Unfortunately, we've had quite a few of those, but there's one that comes to mind. Honestly, I've thought about this one quite a bit, and I think about this from time to time. But I had a financial advisor that I was working with, and she called me in a panic, and she said, "I've got a client, and she has just been. She got back from the doctor, and they basically were giving her days, weeks. I mean, unfortunately, she had a type of cancer that." Was incurable, and she was at that phase of life where she was down literally to days. And so she said, "Is there any way you guys can put together a trust and overnight it up here so she can get this signed tomorrow?" Now, the thing that made this a little bit complex is she had a partner, and she wanted everything to go to this partner. She didn't have a very good relationship with her family, and so she said, "I want to set up this trust. I want everything to go to my partner." And, so on and so forth. And so he said, "Yeah, we can absolutely do that." So we put a rush order on that. We get it overnighted. We get it to her. And then she gave me a call and she said, "I thank you first and foremost for getting this to me so quickly." But she said, "I know I need to get it signed and notarized, but my family just unexpectedly came into town. I didn't know, even though they were going to be coming into town. And they were kind of coming to say their goodbyes." And she said, "I do not want to bring up this trust. I don't even want them to see it because it doesn't include them. Everything's going to my partner, and that's just going to make them upset. And I don't want this last interaction to be like that." So she said, "Can I sign in on Monday?" And I said, "Yes, but if you get a chance, maybe go in, either today or tomorrow and get things signed and notarized," because it was a Friday. And so obviously notaries, banking hours are a little bit more difficult on the weekend. And so anyhow, she said, "All right, I'm going to try to do my best to get it signed and notarized, but if not, for sure, I'm going in first thing Monday morning to get this taken care of." Well, anyhow, I get a call first thing Monday morning from the financial advisor that said she died last night. Didn't sign anything. Nothing was done. Everything went through probate. It all went to the family. Nothing went to the partner. It was, exactly what she did not want to happen happened. Now, obviously, there were a lot of circumstances. That was kind of like a very, very one-off situation. Not a one-off situation, but that was kind of a worst-case scenario that did turn into a horror story. But I've thought about that, and heck, yeah, what could we have done to do differently? And on our side, we really kind of did everything that we possibly could. And I know she was trying to do everything that she wanted to do on her end, but it wasn't meant to be on that. And so it ended up turning into a little bit of a disaster.
And maybe you can help me with this because that signing process is getting it notarized. Do you think that part of the hurdle is knowing where to go to get it notarized, or who do I need to sign this in front of?
Yes, because people ask that all the time. They're like, where do I get this signed and notarized? Probably the easiest place to get something signed and notarized is your bank or credit union. And most of them have a free service. You just call them and say, hey, I need to get some paperwork signed and notarized. And then you can make an appointment and go in and do that. You can also do it at like a UPS store. You can, if you're a member of AAA, they have a notary service as well. So there's a few different places where you can get things notarized. A lot of times people will say, I work with somebody that's a notary. Can they notarize it? And the answer is absolutely they can. The one thing that you can't do is I sometimes hear people, they go, my daughter's a notary. And unfortunately, because they're too close and they are an interested party, meaning if the parents pass away and that daughter was a notary, she's an interested party in the document. So the notaries don't like family members to do that.
I also learned, because we both know Zach Call, he's been on this podcast as well, they're financial advisors, and their office has a bunch of notaries. So in that case, maybe their financial advisor or their office will have something like that to go to too.
That's a great thing, honestly. If you're working with a financial advisor or a firm like Zach Calls and Capita, it's a fantastic thing for you to be able to go in, get things signed and notarized, and then while you're there, you can kind of start the funding process, which that then leads me to the second biggest mistake that people make is not funding their trust. So some people do get over that first hurdle. And they get they get everything signed and notarized, and then they just leave it. They don't do anything. Now, we do have a lot of reminders. We're sending emails. We have annual things. We follow up, verbally every 3 years with clients as well. So we try to stay on top of that, of making sure that people, fund their trust and make sure that all their assets. But that's another big mistake that people make is they spend all this time and money and effort of getting this trust in place, and then they don't fund it. They don't transfer their assets into that. Now we have, very detailed instruction letters, and we have videos on instruction letters to try to make it as easy as possible, but you still have to do it. Because we can't call out to your financial institution and say, hey, we need to update a beneficiary designation or something, because the financial institution is going to go, we can't talk to you. We can only talk to the owner of the account. And if they're not willing to do that, then it doesn't get done with that.
Can you share a little bit more around funding a trust? Like, what does that entail?
Absolutely. So when you're funding funding is just a fancy way of saying transferring your property and assets into a trust. And I always teach people there's 7 categories of assets that get funded into a trust. So you've got real estate, bank accounts, brokerage accounts, life insurance, retirement, personal property, and then business assets like LLCs or corporations or things like that. So each of those assets, there's a certain way that you fund that into a trust. And like I said, we have instruction letters for all of those things, but it's just a matter of going into your bank and giving the bank that instruction letter that we've already prepared, and it tells them, what to do. Now, just as an example of that, sometimes there are more than one way to fund an asset, like a bank account. So you have 2 options when you've got a bank account. One of them is you can go into like if you have a checking or savings account, you can go into the bank and you can leave the account in your personal name. So like if we have a husband and wife and they have a joint checking and savings account, they can leave that in their own personal name. And then all they have to do is name the trust as what's called a payable on death. Sometimes they'll call it a POD, which is just an acronym for payable on death. But that's one option. And that's a very easy and a simple thing to do to fund your bank account. And really all that means is you're saying, hey, bank, while we're alive, everything is business as usual. But if we both die, we're instructing you to pay the money to our trust, upon our death. So it makes it super easy. So that's option number 1. Or option number 2 is you can go into a bank. So this is more common if somebody is setting up a brand new bank account and they already have the trust established, then they can go into the bank and they can actually open up the account in the name of their trust. And it's super easy to do that because they're starting. Now, you certainly can do that if you've already got the bank account established, but the only downside to doing that is a lot of people have like auto draft set up on their personal checking and savings account. And if all of a sudden they're like, hey, bank, I just set up a trust. I want to change the ownership of my checking and savings account to name my trust. Well, a lot of times they'll set up a brand new account with a new account number. And then you have to go back in and redo all your auto pays. And it's kind of a pain in the rear end. So that's why a lot of people go, maybe we'll just stick with keeping the accounts in our personal names. And then we'll name the trust as the pod or the POD.
Nice. I've heard of the pod and POD as well as ways that people kind of avoid a trust will conversation too. Is that something that can come up? And then it comes through comments, right?
Yeah.
Of why would anybody want to designate the trust as a POD rather than like a kid? And I'm kind of taking this a little bit, but you had mentioned last time, like what if your kid dies before you?
Right. And that really, you kind of hit the nail on the head. I get that question a lot where people go, well, we're joint owners on this account, or they'll say, I'm individually own this account. I've named my spouse as the primary beneficiary, and then I've already named my children as the secondary beneficiaries. And then they'll say, is that going to go through probate, when we pass away? And generally the answer is no. If you've got your payable on death or a beneficiary designation filled out properly, here's the three things you have to keep in mind though. And this is what I always ask people is I say, your beneficiaries have to be alive, mentally competent, and over the age of 18. So if they fit into those three categories, then there's not going to be a probate. The money would just go right to them, no problem. But what a lot of people do, not really knowing any better, is they have kids that are under the age of 18. So they're like, well, I've named my spouse as the primary beneficiary, and there's no problem with that. And they'll say, but if we both pass away, we've already named our kids. And I'll say, well, how old are your kids? And they're like, I've got a 2-year-old and a 4-year-old and a 7-year-old or whatever. And they don't recognize that if husband and wife both passed away, a financial institution, they can't release money to minors.
Yeah.
And so then it has to go to court. There's a guardianship and a conservatorship that now has to get involved to manage that money. And then when the kids turn 18, then they get the money lump sum, which again is not really the best age for kids to be getting a big lump sum of money. Because I remember when I was 18, and I can tell you the car I would have bought, and that would not have been a very smart idea as an 18-year-old to do that. But hopefully that helps to answer that question.
No, that's great. And then, so far we've talked about they have done all of this work to put together a trust and they don't sign it. So that's mistake number one. Mm-hmm. They've done all of this work together, put the trust together, and they've signed it, but they haven't funded it. Mm-hmm. And then making sure they get the funding options right. And so the third biggest mistake, and as we were talking beforehand, this actually happened with me and my mom and my sister. So it's another huge mistake when it comes to real estate assets that people make with trusts.
Oh, and it's funny, we were talking about this because my parents almost did this exact same thing. We got talking a little bit about that. But a lot of times parents go, I don't need to do a will. I don't need to do a trust. I'm just going to add my children. I'm just going to record a deed and add them to the title of the house. And that way, if I pass away or if it's spouses and they pass away, the kids are already on title. And like I said, my mom and dad almost did this. This was years ago. And I first started getting into this and I was like, Mom and Dad, you guys need to do a trust. And my dad, kind of an old school, came from a farming background and was like, we don't need a trust. We're just going to put you and your sister on everything. And I said, Dad, don't do that. And he was almost offended. He was kind of like, I'm doing you a favor by putting you on all my assets here. What are you talking about? So anyhow, but I said, there's two major problems with doing that, Dad. I said, number one, I said, if you add me and my sister to the title of the house, I said, if we have any type of a liability, bankruptcy, tax lien, we get sued, we get divorced, I said, guess whose home they can come after? They can go after your house because we're listed as owners of it. And he was like, oh, I hadn't thought about that. I love you guys, but I don't want your liability. And I said, no, you don't. And I said, here's the other problem. I said, if you and Mom pass away, now all of a sudden we're already listed on the title of the house as owners, so we don't get to inherit the property. And he's like, well, what do you mean you don't get to inherit the property? Of course you're going to inherit the property. And I said, well, the IRS doesn't look at it like that. If you gifted that property to us while we were alive, when you and Mom pass away, we're already on the title. We're owners. We don't get to inherit that. And because of that, we then have to pay capital gains taxes. We don't get the step up in basis on doing that. And so, and I asked my dad and I said, how much did you buy your house for? And he said, we bought our house in 1972 for $26,000, which I literally can't even believe that because that wasn't that long ago. I think about that going, yeah, that 50 years, but that's not that long ago. But $26,000. And then I said, Dad, if you and Mom died today, what could you sell your house for? And he said, probably about $350,000. And so I said, okay. Well, if we're already on the title of the house and we sell the house for $350,000, the IRS is going to say, your mom and dad bought this for 26. It's now worth 350. We now have to pay the capital gains taxes on that gain. That's huge. That's a lot of money out of my pocket, my sister's pocket for no reason other than my dad thought he was doing a favor and didn't know any better.
Yeah.
And again, I know that was probably a very similar-ish story to what
my mom had my sister on the deed for the property, so we had to go through and have her take it off and everything.
And we see, it's interesting about that as well. A lot of times parents, they think that they can just go in and sign the deed to remove that child. It doesn't work like that. When you add a child to the title, your sister would have had to have signed in front of a notary as well, and then get that recorded to remove herself. Yeah. It's kind of an interesting thing how title works like that. When you add somebody to the title, you can't just be like, oops, I'm going to remove them now. Now it takes their signature to remove themselves as well.
So take me through, as we wrap up kind of these big mistakes here, how can people either avoid, or if they've made these mistakes, fix them?
Yes.
Some of them seem easy.
Yep. I mean, first one, as I'm laughing as I said, just sign your trust. Honestly, just make an appointment, go sign your trust. That remedies that one very, very quickly. Then the second one is, again, just follow the instruction letters that we have for those 7 categories of assets to get those assets funded and transferred in. And a good majority of the assets that you're moving into a trust, you're doing by beneficiary designation. So instead of naming your minor children, or instead of naming, even your adult children, name the trust as that secondary beneficiary. I failed to mention this because we got off on a tangent here, but another thing when it comes to naming children. So let's say that we have a husband and wife and they have adult children, and they've named those adult children as those secondary beneficiaries. And they're thinking, hey, if we pass away, will that money just go to our 2 adult children? And is there going to be a probate? And the answer is yes, the money will absolutely go to them, and there would not be a probate. But the issue is kids can die. And parents, for whatever reason, they just forget to update the beneficiary designations when a child dies. So if you're going to go down that road and you're not going to do a trust or not a will, and not going to do any estate planning, and you're just going to use beneficiary designations and payable on death designations, you have to make sure and stay on top of those, because if a child passes away, that can create a probate. And a lot of people don't know that, because the way that beneficiary designations work is if we have, let's say we have a husband and I've named my wife as the primary, and then I've named my 2 children as those secondary beneficiaries. Well, let's say one of my kids passed away, and all of a sudden my wife and I got in an accident, and my surviving child goes in and says, hey, financial institution, mom and dad have died. I'm the surviving beneficiary. I needed to give me 100%. They're going to go, well, wait a second. We're looking here in our computer system, and we can see that you're a 50% secondary beneficiary, and your sibling is a 50% secondary beneficiary. Where's your sibling? And they're going to go, oh, well, they passed away before mom and dad. And they're going to go, hate to tell you this, mom and dad never let us know that. So we can give you your half because you're alive and you can sign on that dotted line. But that other half that was supposed to go to your sibling, that now has to go to court and go through probate, because we don't know what we're supposed to do with it. We don't know if it's supposed to go to you, or if it's supposed to go to grandkids, or if it's supposed to go to a charity. So they go, you're going to have to go to court and go through probate and let the judge decide what happens.
Wow. That's awesome. That's not awesome. That's an awesome explanation of what's going on there, right? Because that can seriously complicate things for people to go through that. So as they're funding the trust, you mentioned use the instruction letters that you provide. What if they haven't used you, or they've kind of done this themselves? Can they get instruction letters from an estate planning attorney or business, or how do they do that?
They can. I was going to say, a lot of times, like if they had a trust that they had done somewhere else, if they'd done it with some type of an attorney or a law firm, typically they will have those instruction letters in there. They probably just don't know where to look. But if they looked in the documents, they'd be like, oh, the instruction letters are right there. But if somebody called us and said, hey, we have an old trust, we never funded it, we'd probably have a little bit more of a conversation, though, because my initial knee-jerk reaction would be, how old is your trust? And if they're like, oh, we set this up like 15 years ago, well, things have probably changed enough in the past 15 years that we'd probably want to do an update anyhow. And then when we do an update, we'd give them all those new instruction letters that come with that. Because very, very, very rarely do I ever get a phone call that somebody's like, hey, I just set up my own trust, but I don't really know how to fund it. Can you provide me with the funding documents to do that? We don't really get that question. I mean, hardly. I don't know if I've ever gotten that. In 23 years, I don't know if I've ever gotten that that request. Now that I say that, you know that I'm going to get that request now. Somebody's going to be like, "Hey, guess what?" We'd do it totally with that, but we'd figure something out to help them out.
Perfect. And then the last one, again, if you're thinking from a real estate perspective of adding a child or somebody else on the deed, And maybe, again, maybe you are the child and your parent has done this to you, your recommendations on how to remedy that.
Right. So in a situation like that, then ideally we'd want to set up a trust for mom and dad. We would then record a deed that removes that child and puts it into mom and dad's trust. Or if it's an individual, it doesn't have to be mom and dad, but it gets into the person's trust. And then we can just name the child that was going to be, that was on the title of the property. We just name as the beneficiary of the trust. And we can stipulate very specifically in the trust, this property located at such and such address goes to this specific child. But then when the time comes that the parent passes away, now that child gets to inherit the property through the trust and they get a step up in basis. So in my situation, we ended up doing that. We ended up setting up a trust. Now, my mom is still alive, so all is well there. But when the time comes that my mom passes, then my sister and I will be able to sell my mom and dad's home, and we get a step up in basis. So if they bought it for $26,000, and let's say we sell it for $500,000, we get to sell it for $500,000, and we don't pay any capital gains taxes. So it's great. That's a great benefit for us.
That's awesome. And on our channel, we typically have like hour-long videos. And so with this, we've got a few like shorter videos here. So this one, we aren't going for an hour, but we just really wanted to cover those 3 big mistakes. Yeah. Anything else that we need to add for people? One
thing that came to mind that we get a lot of questions on is people say, are there anything or any assets that I should not put in my trust? And we typically encourage people and say there's really kind of 3 assets that you should really never put in your trust. Now, the first one is cars. And I know that sounds weird because people are like, wait, my cars don't go into the trust? And the answer is technically they do, but in more of a roundabout way. You don't go to the Department of Motor Vehicles and change the title of the car and move it to the trust. That's the no-no of doing that. And people ask and they go, well, why is that? Well, for 2 reasons. If you go to the DMV and you change the title of your car to name your trust as the owner, well, if you got in an accident and all of a sudden they see that this car is owned by a trust, the immediate knee-jerk reaction of 90+% of the population is they go, they must be wealthy. Even though that's a misconception. You don't have to be a millionaire or crazy rich to have a trust, but that's a misconception that people have. They go, oh, this car's owned by a trust. These guys must have deep pockets. Let's try to go for broke. Let's try to go. You don't want to be giving people more incentive to go after you harder for no reason. So that's why you keep the car title in your name. The other reason is for insurance. So if you change the title of your car to name the trust as the owner, a lot of times your auto insurance, they can increase their premium because then they look at it as more of like a corporate policy as opposed to a personal policy, and it can increase that. So those are the reasons why it's not a good idea to put the cars in that. Now, the way that we do put your cars into the trust is there's a document that we prepare as part of the trust. It comes with it, and it's called an assignment of personal property. So personal property, by definition, is anything that's movable. So cars, furniture, jewelry, paintings, clothing, like anything literally that's movable on the inside of your home or garage is considered personal property. So what we have you do is sign this document in front of a notary, and it automatically transfers all your personal property, which is your car, to the trust. So then if you pass away, your successor trustee can then go into the Department of Motor Vehicles, show them the documentation, provide a death certificate, they'll move the title over at that point in time, and there's no court and probate.
Awesome. What else should I keep out of my trust?
Great. Sorry, I just realized that I got on the first one there with that. The second one is life insurance. Now, again, as I say that, a lot of times people will say, should I change the ownership of my life insurance to name the trust? And the answer typically is no. So if you have a revocable trust, the ownership of that life insurance is just going to remain in your individual name or your spouse's name. And then normally spouses will just name each other as the primary beneficiary. That's probably the easiest thing to do. And then the trust becomes the secondary beneficiary. So that way, if husband and wife both pass away, let's say they had minor kids. Well, now the money pays out to the trust as the secondary beneficiary. And now the trust says, okay, now I've got a money manager to manage this money for my children until they turn 25 or 30 or whatever age the trust stipulates. So it allows you to control that a lot better. So just remember, with a revocable trust, you really don't change the ownership of your life insurance, but you do want to name the secondary beneficiary as the trust. That's the best way to do that.
Perfect. And then the last things.
The third asset that really shouldn't go into a trust, and this one is a really big one that really should never go into a trust, is any type of qualified retirement, IRA, 401k, 457, 403b, like a tax deferred annuity, like anything that is tax deferred, you cannot change the ownership. Well, I shouldn't say you cannot. I guess you could, but you're going to get taxed. That would immediately trigger a taxable event, and that's why you don't want to do that. So, so when it comes to tax deferred investments, it's really, really, really critical that you do not transfer the ownership into the trust, because that creates a taxable event. So what people do, especially if they're married, is it's really, really important to name your spouse as the primary beneficiary. So that way, like if I passed away and my wife is the primary beneficiary, she'll get a spousal rollover. So they'll basically allow her to take that, let's say I had an IRA, she can roll that money over into her IRA and then continue to defer that until she's 73. That's a big benefit as as a spouse. So that's why we always like to encourage people on retirement accounts having that spouse as the primary beneficiary. And then there's some different things. A lot of times people will name the trust as the secondary beneficiary, especially if they have minor children or if they have a child with special needs. As long as you have the Secure Act language in there as well, which all of our trusts, we have that new Secure Act language, and that basically allows, so if you name the trust as the secondary beneficiary on a retirement account, it basically acts what's called, they call a conduit trust. So basically, it's almost as if you're naming your children as the beneficiaries, because they still get that same required minimum distribution payout as if they were named on the policy as the secondary beneficiaries. But within the trust, we can control age stipulations, and if one person dies, then it goes to grandkids, and we can control how that money gets to the grandkids. So it just gives you a little bit more control in the trust. But a lot of times we also tell them to refer to their financial advisor and their tax advisor, because they may have a specific situation that makes more sense to do it a little bit differently than that.
You bring up a really good point, and I was at a conference this last weekend with financial advisors around that second generation. So if you have set up an estate plan, bringing in your kids, especially if they're now adult kids, into whether that's a signing party with your notary or your financial advisors, or if your parents have an estate plan, making sure that you're coordinating with their financial advisors. Because again, when all of this happens, if they have a financial advisor that's involved with the family, they know a lot of what's going on in the financial world of that individual, and to be able to make that transition pretty seamless for the kids.
I'm a big believer in I always tell people, be proactive so that others don't have to be reactive to the situation. And the more that you involve and include, the easier it is on the tail end of things. We've had people, like clients over the years, that they're like, I don't want to tell my kids anything. We're going to kind of keep this hush hush. And that's kind of an older generational thing. Like you think about, like, not even necessarily the boomers, but the matures. Like some of those people that are now, starting to unfortunately pass away. But even some of the boomers are in that same category, where they don't want to tell their kids anything. They're like, nope, my parents didn't tell us anything, and we had to figure it out. So, if we pass away, our kids will figure it out. And I'm like, yes, but you can make everything a lot easier, and lives a lot easier for everybody, just being inclusive and being proactive. So that way, if there is an emergency or something happens or goes sideways, everyone knows what they're supposed to do. It just makes it so much easier.
No, that's great. And what I hope happens as people watch videos like this is that as you're talking through these mistakes, or maybe strategies that people can do to avoid these mistakes, it triggers something in their minds of like, hey, I've done this, or I was thinking of doing this.
Right.
And then they can go and remedy that. So if they've already done it, how they can fix it, as you've talked about, but also if they're looking to set up an estate plan or looking for help, now you're a resource for them. Or if they go to somebody else, they know at least how to have that conversation. But if they do want to reach out to you, what's the easiest way to connect with Jim?
Absolutely. The easiest thing to do, really and truly, is probably either to go to our website, go to easylegalplanning.com. We've got all sorts of things that are on there. Or you can email me directly. I mean, really and truly, if you've got a question or you need help with something, you can email me directly. It's just jim@easylegalplanning.com. So it's super easy on that. And we're very responsive with how quickly we get back to people. So if you've got a question, shoot it over.
Perfect. And at the end of all of my videos, I leave secret keywords. So at the end of this video, if they've made it this far, what word should they throw in the comments to prove that they've made it this far?
I was going to say something cheeky around signing, and all
it can be anything.
Now that you put me on the spot on that, I'm like, oh my goodness, let's think here. Pumpernickel.
All right.
How random is that? That was so absolutely random on every level. But if you made it this far, hey, awesome. Pumpernickel.
Great, Jim. Thank you for doing this. And we have some more videos that I think that we'll put out here for people on estate planning. So
love it. Thank you so much. I appreciate it.